All right, good. All right, so this is request of Christine Wheeler, the class on the listing agreement. And so we will get right into it. Let me share my screen. Go. You should be seeing the listing agreement on your screen. Is that what everybody's seeing?
Yeah, looks good to me.
All right, great. So this is the residential listing agreement, exclusive authorization and right to sell. This is the only listing agreement that you're going to use, exclusive right to sell. And when you put it in the MLS, make sure that you put it in the MLS as an exclusive right to sell. I got a call today from an agent saying, what does a reserve listing mean? Because there was she had gone on a listing appointment, didn't get the listing. The seller said they decided to go with somebody else, and it was in the MLS as a reserve list, seller reserve listing. Just so you know, what that means is that the seller reserves the right to find their own buyer. So the seller can find their own buyer and not pay you a thing. And then, but if you bring the buyer, then you get your compensation. So actually, that's not the way to do it. You should get your, if you're going to take the time to list it and get pictures and do all of that, then you should be paid compensation and advertise it. So
Rich, were you answering a question? I couldn't hear what you're talking about.
I was not answering a question. I got a call today. And can you hear me now?
Yeah, I can hear you now.
Okay. I got a call today asking what a reserve listing was, a seller reserve listing.
Okay, got it. Thank you.
And I was answering that. Okay, so this exclusive authorization to sell or right to sell, that's what you use. Always date these. It's not necessarily the date it's going to be signed. It's the date prepared because it matters in subsequent forms. So the first thing is, who is the seller? Now, the seller is John Doe, Jane Doe, or it can be an entity like a corporation, could be a trust. So if it is an entity, then the name of the entity goes here, the trust. The seller is the trust. Now, later, when but the trust can't sign the documents. So when we get to that portion, I'll explain how that has to go. But the seller, if it's an entity, it's the entity who is the seller. The broker is not you, it's the brokerage, because the listing belongs to the brokerage. That's the way it happens in California. Always, this contract has to have a beginning date and an end date. If it doesn't have a beginning and end date, it's not a valid contract. And also, when I get to it, I'll explain it. So it must have a beginning date and an end date. So, and then here is where the address, situated in, wherever you are, Los Angeles or wherever you are in whatever county you're in, with the assessor's number. Okay, if it's a manufactured home, you check here, and then it will attach the manufactured home addendum, where you can also, because with manufactured homes, it's like it depends on whether you're selling the land that's underneath the manufactured home or it's rented. So all of that is handled in the addendum. And then the second check mark here is if it is part of a probate, a conservatorship, a guardianship, or a receivership. If it is, it will then generate the probate addendum. So that talks about court confirmation and all that. So listing price, it must also have a listing price, or else it's not a valid contract. Some agents like to put in TBA. Oh, we'll determine that later. Well, no, I'm sorry, you can't do that. It's not valid. So you must have start date, end date, listing price, address. That's what you have. Absolutely has to go on this contract. Listing terms, other listing terms. It's other things that are a part of this agreement. Like if you should represent both the buyer, if you, the listing agent, you personally should represent, and make sure you specify that you, the listing agent, if Christine Wheeler represents the buyer and the seller, then the commission owed will be X amount. Don't say if Keller Williams Calabasas or Keller Williams Westside or Keller Williams Larchmont represents, because if another agent in the office represents the buyer, then that satisfies that clause. So make sure you're specific in what you're limiting the listing terms to be. So very important that compensation to the broker, the amount or rate of real estate commissions is not, this is very, very important when you're talking about commissions, it is not fixed by law. It's negotiable. You can't say, well, in California, they charge 6%, or in California, we charge 5%. You cannot say that. That is a big, big no-no. You have to say it's customary. You can say it's customary, that it's X amount, but it always say that it's negotiable. So under here is where you would either put a percentage or you would put a dollar amount. It could be either a percentage or a dollar amount. This will be the total amount that you are going to charge commission for the listing agent, the listing side, and the buyer side. That's the total amount. So, and if it's anything below 4, then you need every one of these offices, you need to get management approval. If that is over 4, under 4. So that's that. There's a space to add other other things about the compensation. You can put here. You can also put, seller to reimburse for X amount of dollars for transaction coordinator. You could do any of that right here. So this first A1, if during the listing period, any extension broker, cooperating broker, seller, or any other person procures a ready, willing, and able buyer whose offer to purchase the property on any price and terms is accepted by the seller, provided the buyer completes the transaction or is prevented from doing so by the seller, broker is entitled to compensation. It didn't used to say that. It just used to say, if I brought you a ready, willing, and able buyer for the list price, you owe me the compensation. Well, it doesn't work that way anymore. So you have to I don't know where the chat has gone, because somebody asked a question. I can't see it. But you have to, there has to be a contract accepted, and the seller has to prevent that from closing. I can't see the chat for some reason. So who asked the question? Is there a question?
They just said there was an echo, so I
Oh.
guess it's over with. Don't
Well,
worry about it.
okay. All
It's
right.
old. You sound great.
Okay. Thank you. Thank you. All right. So that is 3A1 is if the seller, if there's an accepted offer, it has to be an accepted offer, makes it that it doesn't close, then you're owed the commission. Okay. So 3A2 is a safe, they call it a safe harbor clause. And what that says is prior to, for a period after the expiration of the list, if someone that had written an offer during the term of the listing agreement ends up buying that property, then the broker is owed. And no, there's one more caveat. If someone who wrote an offer during the period and prior to the expiration of that listing period, the listing agent, meaning you, in written form gave that name to the seller prior to the expiration of the listing, then the broker is owed the commission. So what that means is if you have a listing coming up that's expiring and people have written on that property, written an offer, doesn't matter, they didn't come to terms, they just wrote an offer, it didn't go anywhere. You need to give those names of those buyers to the seller, saying these people wrote an offer, and if they buy your property within this number of calendar days. Now, what is that number of calendar days? Well, rule of thumb that I was taught is that whatever the listing period is, the same amount of time. So if you have a 90-day listing period, then you have 90 calendar days after the listing expires where this safe harbor is in effect. So so that's that clause. Any questions on that clause? Because
Yes.
people up. Go ahead.
Yeah, I had a situation where I had the listing on a property and I showed it, and the people, I was the listing agent, and the other broker wrote an offer, and I presented it to the sellers, and they were looking at it, and then they came back and they said, "We're canceling the listing. We can't sell the house. We're not selling the house." Then they turned around and listed the house. I canceled the listing at their request. And I did make a mistake. I was informed that I didn't exclude these parties, but I had already presented the offer to the people and we were negotiating. The seller went ahead and canceled the listing and then relisted it with another agent, and he got the sale.
So they relisted it with the agent who had written the
No,
offer.
it was
Just
another
another
a
agent.
complete another agent in the
Okay.
area
Yeah.
that farms the territory.
Right. Yeah.
And right in the middle of our negotiation, the guy decides he was just that kind of a seller.
Yeah.
And so I said, okay, I'm not fighting you. We'll
Right.
do that. Then I found out the original buyers bought the house. The people that presented the offer to me and the
Right.
seller was already aware of the deal, but the other agent finished it up. Now, he was kind enough. He gave me a referral fee.
That was nice of him.
Yeah, he
Because
chastised me.
you didn't do that second thing,
Right.
and that is to basically register that buyer with the seller prior, and this is important,
Yeah.
no later than the end of the listing period.
Okay. Even though he had the offer and he knew the
Doesn't
buyer.
matter.
Okay.
Doesn't matter.
That doesn't constitute registering them.
No.
Okay.
No, you have to, it actually is that, you have to submit um, a list of prospective buyers.
Right.
Broker, the very last sentence, broker has given seller a written notice of names of such prospective buyers.
Right.
That's it.
And Rich, can that notice be a letter, or does it have to
Sure.
be a form, or?
No, it's not. It could be an email. Here are the prospective buyers of this property that wrote offers on this property, and per the safe harbor clause in the listing agreement. I mean, you don't have to go into this detail, but I would. Per the safe harbor clause in the listing agreement, should they buy within whatever that number is, don't leave it blank. It needs to have a number. Then I am owed the commission. Now, if they wait to one day after that, guess what? You don't get the commission. But
Okay.
yeah. I mean, it's called safe harbor, so it's you're safe during that period. But once that period is gone, then it's up for grabs. So 3A3, if without buyer's prior written consent, the property is withdrawn from sale. This is a condition that the commission is owed if without broker's written consent, the property is withdrawn from sale, conveyed, leased, rented, otherwise transferred, or made unmarketable by a voluntary act of the seller during the listing period or any extension. So this clause, everybody comes to me with this clause. Well, he's making it he or she is making it unmarketable. I won't show it, won't do this, won't do that. I can't sell this. How can I sell this? So they owe me the commission. Yes, that is true. But let me tell you, it is a battle that you don't want to go through. It's almost, according to legal, it's almost impossible to get that. So Alon, yes, it is. You have to have, regarding number 2, it has to be a written offer. It doesn't matter if you showed it. It's not a list of who was shown the property. The offer has to be written, because it does say that it has to be written. Okay. So if 3B, if on completion of the sale is prevented by a party of the transaction other than the seller, then the compensation which otherwise would have been earned under paragraph 3A should be payable only if and when seller collects damages by a suit, arbitration, settlement, or otherwise, then in the amount equal to the lesser of 1/2 of the damages recovered, or the above compensation after first deducting title and escrow. So if the buyer makes it, defaults, and the seller is able to recover some damages, technically we're supposed to get some of that money.
Mhm.
I've never seen it enforced,
Mhm.
but per the contract, we are supposed to get some of the money. Okay, so 3C, this is where somebody asked, I finally found the chat box, so I was able to look at the chat. I think it was Alon also asked about what about the 575 flat fee commission? This is where you would put the 575 flat fee commission in the listing agreement. So the seller agrees to pay broker and you must call it a flat fee commission. And if for those of you who don't know what this is about, so it's not on all of the offices, but on some offices, I know Calabasas has it, I know Westside has it. There is a flat fee commission that is in the Keller Williams addendum that the buyer signed, that the buyer pays a 575 flat fee commission. And what this covers for the agent, it covers your transaction fee, it covers your legal risk management fee, and it covers your a TC, whatever TC fee. Now, you can charge that to the buyer or the seller. The buyer, it's handled in those addendums. The seller, it is handled here in 3C, but it has to be called a flat fee commission. It cannot be called an administration fee. It can't be called any of that. It's a whole DRE thing. So, D, the seller has been advised that the broker's policy regarding cooperation and the amount of compensation offered to other brokers. So D1 is where you put in what you will be paying a cooperating broker. So we ask that it doesn't go into the MLS under 2.5%. This is going to be tricky, in that, there are listing agents out there who are offering $1, $500. This is the whole DOJ thing that's, with NAR and the transparency of how an agent is compensated, how an agent will be compensated on the buyer's side. I've mentioned this in a couple of meetings that I've had this week, because it was a big topic in the CAR meetings that I attended in Sacramento. The buyer broker agreement is going to have a bigger weight moving forward, and they're revising those 3 forms that we presently have into one form. Hopefully it'll be easier to understand. And they're looking at, I was just contacted to see if I wanted to be on a task force, because they are thinking of making this mandatory statewide. So, other states are doing it. Other states insist that there is an agreement between a buyer and a buyer's agent. So it is happening in other states. So just so you know. So that's where cooperating broker information goes on 3D. Any questions so far on any of this? I don't see any.
Hi, Rich. I have a question. This is Mona.
Mm-hmm.
So on what you just said about states making it a possible regulation for buyers and buyer's agent to have a proper agreement contract, how can we make that happen? Is that something just among brokers, or do agents have a say in that?
Agents don't have a say in it. There's, to make it legislation, there is so many layers to it. I mean, there was talk of they were going to vote on it at CAR level, and even if they had voted that, okay, we're going to make this mandatory and create legislation for it, then we still would have had to take a step back, because then have our lobbyists take a look at it and what that would look like, and what are the unintended consequences of doing something like that. So it just doesn't happen overnight. It just doesn't happen because we all want it to happen or we don't want it to happen. Um, um, it's you know, it basically, it's being looked into and it's being addressed heavily by our state association. So just that's all I can say about that. So seller hereby assigns the broker the above compensation from the seller's funds. 3E is all 3E is basically saying is that we will take our commission, our agreed upon commission from escrow, from the funds owed to you during escrow. So that's only authorizing that. F, the seller represents that he's not previously entered into a listing agreement with another broker regarding the property unless specified as follows. So this is where if you're the second or third or however listing agent on this property, this is where the seller needs to disclose who else had that listing. Then in 2, that he had no other obligation to pay any other broker unless the property is transferred to the following individuals. Who are those individuals? Well, those are those people from 3A2 that the previous broker did their homework and said these offers were written and these are the prospective buyers. So those names are listed here. If there's too many to count or to fit in that place, then you would do an addendum and say see addendum. Okay, if the property is sold to anybody listed above during the time that the seller is obligated to compensate another broker, broker is not entitled to compensation. So that's page 1. Any questions on page 1 of the listing agreement before we move on? Not seeing any. Page 2, it starts off with items excluded and included. And tell your sellers, if you're going to exclude that chandelier that grandma gave you, just change it before somebody sees the property, because inevitably everybody's going to fall in love with it and it's going to be a bone of contention. So just change it. Buy some cheap chandelier and put it up there. It'll save a lot of headache to you, the listing agent, and them. They really want it. I mean, my house, when we sold our house like 3 or 4 years ago, there was a chandelier. There was a couple of chandeliers actually that we decided to keep and we changed. Now they sit in our garage. I don't know why we kept them. So, but anyway, so just change it before.
Yeah, it's interesting. I had a situation years ago where the listing agent was the seller of a property in the valley, and we went through, did the buyer. We ended up buying the house and everything, and the day we closed escrow, and then we took possession. We walked back into the house, and lo and behold, all the doorknobs and hardware were taken off of the cabinets.
Oh my God.
Because during the inspection, she overheard my client say, oh yeah, we could probably change those things. So she figured, she didn't ask, she just took.
Right, exactly.
And that became a big problem. I went back to a very reputable broker at the time, and I said, one of your agents really couldn't do what they were supposed to do. And he says, well, what are you going to do about it? I go,
and what do you do about it? You really can't do much about it except have the seller sue in small claims court after.
No, I was already threatened with my life. Her husband
really?
was, her husband was. So I said, pick out what you want. and
And I'll buy them.
I'll pay you for them, whatever the cabinet doorknob.
That's another thing. Yeah. And here's the thing. If you are excluding them, you put it in the MLS that X thing, these are
Right.
excluded from the sale. But when you get an offer as the listing agent, that needs to be also put into the offer. Because
Right.
what's in the MLS doesn't automatically transfer over to the actual contract.
Right.
So just because, well, it was in the MLS, well,
Yeah.
it doesn't matter. So make sure that goes into the offer.
Yeah.
So leased items is very important. If you know of any, well, they should know if they leased anything or there's a lien on anything.
Yeah.
Make sure that you check that and you know about it. The MLS. Number 5 describes what the MLS is. And very important, the information that will go into the MLS. Make sure that your seller knows that all of this information we're obligated to put in the end, the terms of the transaction, including the sale price and the financing. All of that goes into the MLS, and it is sent out over the universe. C5C is what MLS you belong to. So make sure you put that. Everybody my different offices, they all have different MLSs that they belong to. Number 6, the impact of opting out of the MLS. Make sure you go over this with your seller. My seller wants it excluded, doesn't want it on the MLS.
Right.
I question that. I'm sorry, you don't want to have the most exposure of your house to, I mean, there are people, celebrities and all that stuff. There are legitimate reasons not to widely put it onto the MLS, but you want to cast the widest net. So
Right.
how do you do that? You put it on the MLS. So if go over this section, it's in a box for a reason, because it's important, and make sure that your seller initials that they've read it. This is the new paragraph that started May of 2020. Public marketing of property, clear cooperation. There is not one office that I have that their MLS, or not at one MLS that from all of my offices, that doesn't have clear cooperation. They all have clear cooperation. And what is clear cooperation? That within 1 day of a listing being publicly marketed, meaning being put on the MLS, it needs to go on to the MLS within 1 day of publicly marketing. That means if you put it on social media as it's coming soon, I've got a new listing. Oh, look at my great listing.
Well,
Guess what? The next day that has to go into the MLS because you've just publicly marketed. If you send pictures to another broker in a different office, even a different Keller Williams office than the office that you were in, you have publicly marketed it, because that agent at another office is a member of the public. Technically, they are not part of your office. So it's very important that you go over this with your clients. If they want to exclude, well, I'll get to exclude on the next page, so I'm not going to talk about that. Also on here is coming soon. Now, coming soon in these different MLSs is different. The MLS, which strangely enough, in the beginning of clear cooperation and coming soon, did not allow showings, now allowed showings. And ChrisNet, which allowed showings in the beginning, now doesn't allow showings. So you can have a listing across the street from each other, one in the MLS and one in ChrisNet, that one allows showings and one doesn't.
Right.
It doesn't make sense. I, as president-elect of SRAR, I don't we have tried to come to an agreement with all MLSs in the area, but the MLS wants their coming soon to be this way, and they have every right to have it that way. Now, what they are going to do, and I don't know if they've implemented it yet, but if you are going to allow showings in a coming soon status, that listing will start to accumulate days on market. So at least that problem has been solved. And that was the problem that I had when I was on the board with ChrisNet, when they were doing their coming soon. I argued it makes no sense. There's no difference between this and an active listing, except that it doesn't accumulate days on market for 21 days. Well, they changed that. So, and at least the MLS will now start accumulating days on market. So that is coming soon. Make sure your client knows what coming soon is, because you have a right from the day that this contract is executed. If you haven't done any public marketing, you have 2 days to get it into the MLS, or you have 2 days to exclude it. So, so it can either go into the MLS as a coming soon, or it can go in as an active.
Well, I got a question.
Sure.
I've been looking, and I have a client that doesn't want to put her property in the MLS. She has agents going through, and quietly I'm telling some of the agents that I work with about this property. But I've been looking through I get emails all day long from an organization called TAN, Top Agent Network.
Yes.
That started about 15 years ago. It used to be free, and you had to qualify to be a member. Now of course they're charging, and they're out of San Francisco, and they have rules and regulations that they've set up, saying that it should go in the MLS, but it's not really going in the MLS. And now these are top agents that are working in that specific area, and they're marketing outside of the MLS. And the only way you're going to get the information is to be accepted into their group.
Right. But that's public marketing. That's
public.
Even though it's a private group, it is marketing outside. And by the way, TAN is suing everybody because of clear cooperation. So far they've lost. But that is public marketing. And Dave, it worries me when you say I've got an excluded listing and I've let some of the agents that I work with know.
I have a verbal agreement. It's not a listing. If it was a listing,
okay. If
it was a listing, it would be put in the MLS. I do it by the book. I've been doing this too long, never had a complaint, never had a problem. If they don't want to do it the right way, we just don't do it. Simple as that.
Right. Because ChrisNet, I know you're not a member of ChrisNet, but ChrisNet, the fine for violating clear cooperation is 1% of the sale price. That is 1%. You're giving up 1% of your commission if you violate clear cooperation.
Well,
Now,
1% of nothing is nothing, you know. It's okay.
No. Well, I mean, but they can, if they find that you're in violation.
Yeah.
But even before you get a commission, you're fined. So, you owe it. So,
yeah, I owe it. They're going to take it out of you.
They're going to take
They can take it out of my dues. Okay.
Right, exactly. Okay, so that
Rick,
is
can I
page
quickly ask
2.
a question?
Sure.
While we are at the subject, if hypothetically, if somebody tells me I want to sell a property and it's only off market, is that okay to share with somebody in other,
Here's my question is,
Yes.
So you're saying that a seller came to you and I want to sell my property, it's off market. I'm not gonna sign a listing agreement, but if you bring me a buyer, then I'll then I'll pay you a commission. Is that what you're
Exactly.
saying?
Yes.
Okay, then that's not a problem, because you don't have a listing agreement. Although MLSs are trying to say that that's a violation of your agreement with the MLS, blah, blah, blah. So, but technically that is not a violation of clear cooperation, because a listing agreement doesn't exist. So they can't police an agreement that doesn't exist. So
Yeah, verbal is verbal and it
verbal,
doesn't
right,
stand.
exactly.
It
But
ain't
make
in
sure
writing, it
before
don't
you,
count.
but make sure before you show that property, you get either a single party compensation agreement or a commission agreement signed before you show the property. And so make sure you
Unless you know the
do that.
people really, really well.
Right. Yeah.
And then don't count on it.
Okay. So
Thank you.
seller instructs broker at the very bottom, D, instructs broker to market the property to the public, to not market the public. So it says right here, MLS may require CAR form, SCLM, or local equivalent. Every single MLS that I am talking to, that all of you belong to, requires a secondary document, and SCLM does it. The MLS has their own, but you can still use an SCLM. But everybody requires this document be on file somewhere, even CRMLS, which you don't have to send the documentation to, but you still have to have it. So a lot of agents think, well, it's in this agreement. No, you need this additional form, and you're either going to market it until a specific date, which is D, or you're not going to market for the entire period of the listing, which is perfectly okay. So and here's the thing, if you say I'm not going to market for the whole period, and then you change and the seller changed their mind, you can always change that. All you have to do is do a modification of terms. So saying, property will be put on the MLS such and such a date. Just so you know, while it's excluded, it does not accumulate days on market. Does not accumulate days on market. So that's excluded. Never check box clear cooperation policy does not apply, because clear cooperation policy applies to all of our MLSs in our area. MLS data on the internet. Make sure that your client knows that this is going to be out there. And I know that buyers ask after the close of escrow, oh, can you, I want the pictures removed. They cannot be removed because per MLS rules, a listing has to, the data integrity of a listing has to be maintained, and the pictures are part of that data. Now, there are some agents who, prior to close of escrow, they remove all pictures except for one. But the problem with that is that you're never going to get a true comp from that listing, because nobody knows what the inside looks like. But it has been done. But after the fact, it cannot be done. So just so you know, 8B talks about feature opt-outs, and this is where, see, the MLS is a private little club, just like TAN is, but we have subscribers and all that stuff. But then the MLS just distributes that data out to third parties. those are your Trulia, those are your Realtor.com.
Zillow.
It's not, no, Zillow is a brokerage now. We always
that's
have
right.
to remember that Zillow and Redfin are brokerages. They are not third parties anymore. So, so it goes out to these other areas. Now, a seller can opt out of that, and that's using the SELI. That's the seller exclude listing from the internet. So it can be not put out there, but if it's out there for one day, it's out there forever. The whole thing with the pictures and whatnot is, it's like, even if you were able to get the pictures off the MLS, you would never be able, I don't think, to get the pictures off of the internet, because once it's out there, it is out there. Okay. So, so that is the MLS. Seller's representation. Seller represents that he is unaware of any notice of default, that he, any litigation, any of that. That is number 9. If there is, then they need to disclose it, obviously. Broker and seller's duties. We all know what the broker and what our duties are, is that we're going to market this property and do our best to sell it, get the best price, and presentation of offers. All offers need to be presented to the seller. That's per ethics and per MLS rules and whatnot. And unless the seller in writing instructs you not to present certain offers. If they say to you, I won't look at an offer under $1 million in writing, then if an agent sends you an offer for 999, you need to say, I'm sorry, I cannot present your offer to my client because the seller has instructed me not to present any offers under $1 million. So as long as the seller does this in writing, you're perfectly fine. Otherwise, you need to present all offers at any time. If you're in escrow and you get another offer, if somebody gives you another offer, you still need to show it. So just know that. Then there is this very important thing about buyer's love letters. And I will tell you that in the spring edition update for the DRE commissioner, he talks about buyer love letters. So I suggest you go to dre.ca.gov, and they have like a floating, ads. And one of them is commissioner update. Click on that, get a copy of it. You should be reading it whenever it comes out. I believe it comes out quarterly. It has good information there. And, the DRE, just like CAR, we frown upon buyer's letters because of the unintended bias that the seller may have to certain classes of people that may expose them to a fair housing violation. So it's really important to, in California, there's like 22 classes of people who are protected, are protected classes. And, a letter from, I'm a single mother who really would love your to be in your house. Seller may be influenced by that. So take that offer over a better offer from a single person or somebody who doesn't have children. That's in it. That could be a fair housing violation. So it really exposes your seller to a lot of stuff. So here, the seller can instruct the broker the default is not to accept buyer letters. That's the default. Or B, seller instructs broker to present buyer letters. And there's that wonderful, you're going against broker's advice. So that's really important. 10D, seller agrees to consider offers presented by broker and act in good faith to accomplish the sale of the property. So investigations and reports. Seller agrees within 5 days of the beginning of the day to order the used for the whole state. In Northern California, they do inspections prior, the seller does inspections prior to the property being on the market. So that's kind of what this is geared toward. But here down in Southern California, the seller has every right to do any inspection prior to, although then whatever inspection they do, they have to give to any prospective buyer. So,
And Rich, and in
yes.
certain municipalities, they require them to get permits before they put them on the market.
Well, yeah.
Pasadena, for one.
Pasadena's kind of loosened up, I think,
Well,
because when I sold a house like a year and a half, 2 years ago in Pasadena, and it was the seller had to go online and say, we did this, we did that, we did, and there was never an inspection, and they approved. I mean, so I think they've lightened up a little bit, but cut to a couple of years before that, I had a condo, and they had to, there was an inspection that I had to, have in order, for it to be okayed for sale, and if there was anything,
last
So-
week they had one that came out and they
Oh, yeah.
priced it low because there were violations,
Yeah.
and the seller had to be required, the
Yeah.
buyer had to be required to fix those things before they could close escrow,
Yeah.
which was interesting.
Unfortunately. Yeah. Okay, the deposit. Broker is authorized to accept and hold the deposit on behalf of the seller. Alon, I don't suggest that you check anything, and I wouldn't do anything. Anyways, so, but I would say to you, don't accept a deposit on behalf of the seller. Do not touch a check. The minute you touch a check, it's got to be logged. It's got to, just don't do it. It's like nobody does it anymore, but there are certain agents, who still do it. And so I don't touch a check. Agency relationships, the AD, the disclosure, this is required by law that we have to, and that's why this document is the very first document that is bundled with this agreement, is an agency relationship, because it is required by law. And Dave, I know you know this, that years ago it wasn't done this way, and you had to pile these documents in a row, and that's the first thing that you had on top, because that's the first thing you needed signed. So possible dual relationship with a buyer. Talk to your seller about having dual agency. If how do they feel? If they don't want you to be a dual agent, I had a client who didn't agree, and it's like, okay, I'm fine with that. Sometimes it's a tightrope that nobody wants to walk, because you're playing both sides. So, but if you have the conversation and they are fine with it in writing, then you're good to go. You've had that conversation, and also tell them that anybody in my office, it's considered dual agency. So, because once again, it's not the individual agent, it is the brokerage. Potentially competing sellers and buyers. This is important too. Hey, my office lists many different properties that are similar to your property, and so you will be competing with that. I work with many different buyers, And so, you know, that may be competing with your listing, just to let you know. And that's why possible representation of more than one buyer or seller, disclosure and consent is also bundled with this. Next, very important, security, insurance, showing, audio and video. They added audio and video because why? Because so many people have Ring doorbells and or they have cameras in their house. You know, there are many cases about, you know, a buyer's agent standing out front talking about the listing, and the seller was listening all along. Well, we can go, you know, I can go, I'll go up to 1 million, but let's put in an offer for 975. So that seller knew they would go to 1 million. So it's like, okay, you know, so that's, you need to disclose that. So, but the more important thing is security and insurance. And hey, we, our brokerage, whatever brokerage you're at, we don't cover you for loss, you know, theft or anything during an open house, or, you know, have insurance on your valuables. And if they are so valuable, put them away, lock them away, move them to mom's house, do something with them, because we will not be responsible for it. So that's important to note. They need to have their own insurance. Photographs and internet advertising, you know, we kind of went over this with prior, and the seller can check a box saying, I don't want any images of my house on the internet. The problem with that is the MLS requires one picture of the exterior of a house at the very least, or else you're in violation. No, Mona, they're not responsible for breakage either. It's like, no, they're not. So yes, the seller can say, I don't want any images. Seller acknowledges that prospective buyers incoming the property may take photographs or videos. So there's a box here to instruct everybody that they are not to take any photographs of the property. So and here's also, if you have a listing and, you know, somebody else, another agent from another agent period, comes in and is doing a video of your listing saying, oh, look at this great listing that's here, blah 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 blah, that's a violation. They're not allowed to do that unless they ask you if they can do it prior. So make sure that that is handled. Lockbox. If they want a lockbox, there's a separate form that pops up if they want a lockbox. If they don't, then you check this box. Tenant occupied talks about if the seller does not occupy the property, seller shall be responsible for obtaining occupants' written permission to use the lockbox, because there is a portion of the lockbox addendum that the tenant would have to sign. Do they want to sign on the property? If they don't, then they check the box. Equal opportunity housing. This is fair housing and discrimination laws. Attorney's fees. The non-prevailing person would pay the fees. So there's additional terms and additional things that you would have for this listing. If it's an REO, which is bank owned, short sale, trust. If the seller intends to include a contingency to purchase a replacement property, you let them know that. I would also add to this that the affiliated business addendum for each of your offices, you should be having the conversation with your seller about what services we are affiliated with. And if you're recommending those services like the NHD or whatever, escrow or home, we don't have any home warranty thing, but or a lender that we work with, you should be having the seller sign at the time of the listing an ABA. So just to let you know, management approval. Management gets to say, if there's something wacky about your listing, the management within 5 days gets to say, you know what, we're not taking your listing.
Rich, can you repeat that one thing you just said? You should really have your seller signing what? I couldn't hear it.
The ABA.
Oh,
The
ABA,
AB
okay.
Yeah. Successors and assigned. So this agreement is binding upon the seller and the seller's successors and the signs. What does that mean? It's still a valid listing if the seller dies. That's one of the things it means. If the seller assigns the property to somebody else, it's binding to that other person. So just be aware of that. I did have a case where somebody passed away. We ended up canceling it, but technically we didn't have to. So as in all of these agreements, mediation is if there is a dispute, we have to go to mediation. That is agreed upon in this agreement. What's not agreed upon is arbitration. It used to be in this agreement where you can ask about arbitration. But they took it out because the buyers or sellers would bring in the brokerage if there was a dispute between buyer and seller. Once that agreement is in, and they would tie it back to the listing agreement, so they took it out. That's the reason why they took it out. This is the entire agreement. As Judge Judy says, the agreement is the four corners of this thing. So this is the entire agreement. Anything else has to be in writing. So if it's not, well, we verbally agreed, but no, we didn't verbally agree. Also, going back to where I said, I'll just flip back just because I just thought of it. Where the flat fee commission, you can always also put $500 for marketing materials or whatever, the seller agrees to pay for this. So if the seller agrees to pay for your marketing or your photos, put it here. So sorry, I forgot about that. Ownership, title, and authority. The seller warrants that they are the owner of this property. How do you make sure that they are the owner of the property? Well, before you go on a listing agreement, you should be pulling a property profile. At the very least, pull a property profile from Realist. But if you have a great relationship with the title officer, pull a prelim, because then you know how much their mortgage is, if they have a mortgage, if there are any liens. Somebody told me there was some sale, some listing, and they got to come to find out when they got into escrow, there was like an IRS lien for the seller, and do you know how long it takes to get rid of an IRS lien? I mean, oh my
Yes.
gosh. So you should know this going into this,
Right?
because it could be a challenge. This is your business. You choose who you want to do business with. So just know that. So representative capacity. So as I said previously, the seller is going to be the entity. But then if there is an entity like an LLC or a trust or anything like that, then you're going to click this as a representative capacity. it's nice that they got rid of it on the offer, but here on the listing agreement, I think it has survived. I hadn't heard whether they're going to update this, but anyways, it's here. You need to fill that out. You need to fill out the representative capacity. So, which tells what the entity is and who has the authority to sign on behalf of that entity. So if there are two people required on a trust to sign on behalf of that trust, so John Doe co-trustee or John Doe trustee, it doesn't really matter how you put it, and Jane Doe co-trustee or trustee, they're the ones who signed this, not the entity, not the John Doe, Jane Doe trust. So that's how it needs to be signed.
Right.
The seller is the entity, but the authorized individual is the one who has to sign. A person has to sign as either the trustee or the managing director or the authorized signatory or whatever they are. They're the ones who sign. And if there's more than two people, then you need an ASA, which is an additional signature addendum. So, and then the broker, you as the broker, sign here. If there are two different companies, if it's a listing between two different companies, then you would do an ABA to bring in the other brokerage. So there was a question in the chat, if it's a husband and wife, one signature only needed to list, two signatures to sell. It's really not true. I mean, if two people are on title,
They both have
how
to sign.
how can only one authorizing a listing be valid? I mean, I mean, here's the thing. I mean, people have gotten away with it, but as one of my very smart attorneys says, if there is a possibility of an argument, if an argument can be made, then it really can't be done. So, and an argument, if only one person of two sign, then it's not valid. So
It's open to interpretation.
right, exactly open to interpretation.
I sat there and listened to that.
Yeah. Then also attaches the seller advisory saying, all about, all these things you need to know, disclose. So that is basically the listing agreement. I've gone a little over, I'm sorry.
No, it's good.
Does anybody have any questions while I'm here? I don't see any, I don't hear any. So I told you, and I don't see, oh wait, yes, checking, checking. I had told in in Calabasas' meeting, I said, my next class is going to be disclosures. So tell me what disclosures you want me to go over. So you just email them to me. I will do my best to get as many in as I can. So if there is no other, when would you ask for rent back? Well, where you would ask for rent back during the offer. And here's the thing, and here's what I've been running into this. I've been running into this a lot with agents. They're in the middle of escrow and they're just now doing the SIP or the RS or the RLAS. It's too late. You don't have the leverage at that point. So when that offer is made, get those forms done. Get the details of those forms, work them out. That's what that time is for. When you're negotiating at the end of you were in the middle of a deal, somebody always has the upper hand. And most likely it's the buyer, and the seller wants this, but the buyer doesn't want, if you're asking the buyer to rent back for 60 days when as opposed to the 30 days you originally did, in the middle of escrow, guess what's going to happen? It's not going to happen. And, deposits and, paying PITI, that needs to be settled at the time of the offer. It really does, because otherwise it's too late, and somebody's going to be pissed off, and it always turns to be pissed off at you. So it does. It's your fault.
That's why we make the big
you do
bucks.
this? It's always, and then I get a call, and then it's like, so.
But
So
it's
yes,
rewarding,
please.
Rich.
Yeah.
It's rewarding. You learn a lot, and you learn, our business is unique. We do all the work, and if we're really good at what we do, we get compensated.
Yeah.
Everybody else, the lawyers and everybody, they charge by the hour. And, I'm waiting for that day to happen. If I can get $17 an hour on some of my transactions, I'd be very happy.
Yeah, right. Exactly. Not seeing
Not
any
complaining.
more. I am going to 7CRE coming soon. Can the listing agent not utilize coming soon, even if the seller did not object? Sure. You don't have to use coming soon, Elon. It's an option. It's an option available to them.
Right.
So with that, 15 minutes over, I am going to stop the recording. And